Welcome to Environmental Law course, dear learner and viewer. In continuation to our discussion on the forest law and policy in colonial India and forest laws and policy in independent India, we have taken note of the forest laws and policy right from 1855 down to 1980 and 2004, the Forest Handbook guideline. We have seen that how there has been a radical shift from the colonial policies of the forest and laws in the independent India, although we can say that the forest policy 1952 had a large impact of the colonial hangovers, and but there has been a sign of change, a new wave of change which has started right from the 42nd constitutional amendment in 1976, which have elevated the status of the forest to the directive principles of a state policy, and it brought the forest from a state list to concurrent list under NT 17A of the 7th schedule to the constitution, and then promulgation of the Forests Act in 1980, having a very small act but having a far reaching consequences and implications, have resulted into the increase of the forest cover in this country by hitting hard on the issue of the reservation and de-reservation of the reserve forest and conversion of the forest land to non-forest purposes, and constitution of the authority to look at the twin objective of the conservation of the forest and to see that how the forest conversion into non-forest purposes can be combated and prohibited, and in the what exceptional circumstances it is to be allowed by the central government. We have also seen a change, a sign of radical change in the forest policy enumeration of 1988, taken together the Forest Conservation Act and Forest Policy 1988 with the catena of the cases prior to 1981 and after 1981. We have tried to take a very brief survey of the case law, and then finally we landed to see that what are the broad ratio and the policy goal which has been decided and which has been handed down by the Indian judiciary in a T.N. Godavaran cases known as the forest conservation cases 1997 till the T.N. Godavaran has died just 2 years back. So his activism in the arena of the forest conservation is something very remarkable, and he has rendered a very yeoman services in India to see that how the prime objective of the Forest Conservation Act are to be met, and he is also attributed to look at the entire issue in a very holistic perspective. The one perspective was that certain minor changes happens bound to happen in the forest area in the name of development, in the name of highways, in the name of portways, in the name of other developmental activity and the mines and minerals. So therefore, that to find a via media the compensatory afforestation fund have taken the shape of a law in 2016, and it was made incumbent that any felling of the trees and deforestation and denudation of the forest area and the green cover is going to be compensated by depositing a fund known as the Compensatory Afforestation Fund Act 2016. And we have also noted that how the Comptroller and Auditor General have complained to the fact that despite a very hefty amount is being deposited under the fund, it remains largely utilized, largely remain unutilized for the purpose of reforestation, afforestation, social forestation and compensatory forestation. So thus we see that there is no dearth of money, there is no dearth of will, there is no dearth of the policy backup, there is no dearth of the law, there is no dearth of judicial intervention on the issue. But what remains to be done, that there is a need to a concerted effort to raise the forest coverage in this area. A logical outcome and a natural sequel to the development of the T.N. Godavaran cases concerning to the northeastern state, a very novel development has taken place by the third lecture, which focuses on the point that how the it is moving from Forest Conservation to Forest Right Act 2006 and Panchayat Extension to Scheduled Areas Act of 1996 have given a new twist and turn into the entire question of forest conservancy and restoration of India's forests. How these two enactment happens to be is a kind of a very remarkable epoch-making enactment to confer the centuries-old discrimination which have started from 1855 by the regulation of the colonial masters in relation to the forest, and there has been the continuous alienation, disenfranchisement, disempowerment of the common people, indigenous people and the scheduled tribes in scheduled areas to see their inherent and inalienable right and their sense of belongingness to the forest resources in this country. How these two laws have tried to fill that void is the prime focus of this lecture. Let's see that how we wish to go about and for the study of these two enactments to look from forest conservation to forest right regime or a right-based forest conservation or a right-based forest management in India. We see that the tribals have a historically dependent on the forest for livelihood and culture, and their rights were ignored during the forest reservation which has started in the colonial India. Article 15, 14 and 46 ensure equality of protection for the scheduled tribes and scheduled castes in India, and the 5th schedule to the Constitution of India is a ready reckoner to see that what autonomy has been granted to the scheduled areas under the Constitution and what rights are being safeguarded in the scheduled areas and how the special status has been conferred by the Constitution in the 5th schedule vis-a-vis the constitutional provisions of right to equality under Article 14, 15 and 16 ensures the equality of protection of the scheduled tribes in this country. They were historically discriminated, and that historical injustice happens to be redressed by the Forest Right Act, and which has been said that the Forest Right Act in right earnest try to see some therapeutic perception of their historical discriminations by known as that the forest dweller have been wrongly treated as an encroacher and there has been a misnomer, and the faulty survey have displaced a lot of the tribal people, and their alienation has proved very deleterious in management of India's forest, because once the state have sanitized the local people from the forest area and have tried to see the entire forest management into their hand, then there are certain problems and repercussion, and that repercussion, their sense of alienation have resulted in the denudation of forests in a very fast manner. Therefore, under this realization of the historical justice, India's forest resources and the tribal presence are something that is a concurrent phenomena, and now these two laws are going to see that how their presence and autonomy and their participation and their belongingness can be restored and can be kept intact with the international context, wherein we see that the international law which also try to recognize indigenous people, especially the ILO Convention 169/107 is something which is rooted to the indigenous people, and they have their sacrosanct right, and we have to see that in the international legal context, the rights of the forest dwelling community, how they are going to be aligned in the Forest Rights Act, and what overlapping has happened and what forest and revenue jurisdiction have compounded some kind of the confusion which resulted into forced eviction, and it remains a large number of unresolved claim and incomplete survey of the forest dwelling community. With this, we will try to see that what have gone deep into some of the studies and some of the committees which were given the term of reference to look at the recommendations or to ameliorate their discriminations and their conditions of the traditional rights of the traditional community, and how the forest policy 1988 happens to also demarcate and devote some attention to the role of the community participation. How with the passage of the time, in the catena of the cases, the Indian judiciary have also was of the firm view that the space which they were given must be afforded and accorded in a legal domain before their rights are going to be extinguished and they are to be evicted from the forest land. And it requires a very fine tuning and the balance between the conservation requirements of the forest vis-a-vis the life and livelihood of the forest dwelling community and their realization to right to life and human right. With this, we see that the Forest Right Act of 2006, the structure and the purpose is to be gauged from the fact that it has 6 chapters and 14 sections, which recognizes individual right at one place and the community right at the other place. Therefore, the forest right talks about the ownership which is individual, and as well as it tries to recognize the ownership which is community or communitarian in approach. So, the communal sense of the property and the communitarian sense of enjoyment of the property and the community right is being accorded by the Forest Rights Act 2006, and it tried to see that how in the gigantic task of sustainable use of the forest resources we can involve and we can bring the tribal community to the fold, and this will not only redress their historical injustices, but also will lead to a very sustainable management of the forest. Therefore, the key definition which is underpinned under this law offers definition of the scheduled tribes, other types of forest produce, and in the forest land and the habitat and the critical habitat, how their rights are to be going to be implemented and how the strict scientific process and the Gram Sabha consent for a minor forest produce realization and their rights in matters of the forest village, revenue villages, unsurveyed settlement and traditional village are going to be claimed and going to be implemented. In this respect, we see that the Forest Right Act for the first time have defined the minor forest produce, and the ownership and collection and sale and processing right have been given, and no royalties or restrictive permits are required, and therefore, the state duties for minor forest produce is to remove forest corporation monopolies, and it has abdicated and it has removed all kind of the monopolistic tendencies which were permeated under the colonial regime of the forest management in this country, that the state has been given power and they have supported the pricing, trade and value addition to the tribal community, and this is applicable to forest villages, revenue villages, unsurveyed settlement and traditional villages, and thus it tries to see the conversion of the forest villages into the revenue villages for the ownership, collection, sale and processing rights and of the tribal community and the forest dwelling community. In this regard, the role of Gram Sabha and the forest right group happens to be central, and their claim, verification and conservation in relation to the minor forest produce is to be protected as a matter of right to cultivation, right to reside, right to access the resources, and conversion of pattas and lease to some extent to the ownership and title. Thus, from individual right to the community right, they have a communitarian right of grazing, fishing, seasonal access of all kinds of water bodies and they have the habitat right. That community right also takes shape of a habitat right and the joint management of the forest and their cultural realization. Why it is so? Because the fish out of water and tribal community out of their culture cannot survive, and it is this realization that we see that they have been given and afforded their due place and recognition in matters of conservation of forest vis-a-vis conferring the rights of the forest in the forest area. Now, we see in this context the customary and cultural right is very important, like Mr. rights, traditional practices of cultural and spiritual link to the forest landscape. And this is visible recently when there was, I happens to see the Sarna practice in the Jharkhand and the Sarna marriages, and the Sarna practice has its origin into what we can say the customary and the cultural right of protection of the tree and the coverage of the forest, and this is something embedded in their culture, deep rooted in their culture in the state of Jharkhand, and that Sarna practice is to be studied in the context of Jharkhand to look at the entire issue in a very piecemeal manner, but a very magnified manner also, to see how the customary right and the cultural rights of the scheduled tribe happens to be recognized, and the process of multi-level recognition is something made to be very flexible and not made subservient to exacting standards of evidences, but the oral testimony can be considered because the tribal people have their right which is inalienable since centuries, but when it comes to showing some documentary proof and some title, they can defy because they don't carry any kind of a title. This is a kind of a customary right which they have been carrying since time immemorial. So, therefore, there should not be exacting evidentiary standard to confer their rights, and the community forest resources right which is West, that the Gram Sabha must protect it and conserve or manage, and the Gram Sabha is also enjoined upon to regulate access and prevent all kind of practices which are derogatory to the forest conservation. In this respect, we will also try to see that rights in national park and sanctuaries which have recognized a very limited sense. So, even inside of the protected areas, they after their consent, they should be suitably and fully rehabilitated, and it requires that the small forest diversion for a school, hospital, roads can be allowed to the extent of 1 hectare or less than 75 trees with the government or the central government's approval. Thus, we see that the protection against the eviction should be afforded to a great extent, and as a matter of policy that eviction should be avoided and they are to be fully settled and rehabilitated before they are going to be relocated. So, the protection against eviction means rehabilitation is mandatory before relocation, and it is the duties of the forest dweller to protect the wildlife, forests, water resources and heritage and follow Gram Sabha conservation rule in right earnest as a pious obligation. At the same time, the law also tried to see that the community-based conservation should go in an eco-friendly manner, and all the customary and traditional practices are allowed to creep into the entire question of the management and the governance of the forest. Therefore, the empowerment and of the tribal community appears to be that they are the vanguard and the custodian of the forest resources, and in that context, whatever has been permeated under the Forest Right Act of 2006 have also been extended to Panchayat extension to scheduled areas of 1996, because after the promulgation of this law, we see that some adjustment are required. Some adjustment are required into the another concurrent law into Panchayat Raj extension to Scheduled Areas Act 1996, and we will also be discussing from that point of view that how this law along with the forest right law have given a very broader image and picture that how the forest dwelling community are to be empowered in matters of forest conservation and forest resources. We try to see that it is because of this effect that gradually we are witnessing some kind of a pleasant note of hearing that expansion of the forest cover which is gradually taking place, and it is because of the tribal and forest rights conferment of their due rights, it is possible that we have to see that Indian law and the tribal right in a constitutional perspective, and we have to look at the special status which is afforded under Article 342 by notification of the scheduled tribe, and we should also see that how some of the areas are being reserved, and that is given under section Article 322, 332 and 334. So, a combined reading of the constitutional provision or the special provisions relating to tribal community in this country, and know from the very source of the Constitution of India is the background, and that is the background of having this kind of the law, and along with we see that the educational and economic protection which they require, and as well as their right to equality and free from all discrimination have paved the way of the law. Then we see that besides 340, 244 which talks about the administration of the scheduled area, and especially when we talk of Panchayati, the law in point we just discussed about, we just hinted about, is the fact that the law which talks about the Panchayat extension of nomenclature as Panchayat extension of the Scheduled Areas Act of 1986 is something drawn from the very strength of what we call Article 244 of the Indian Constitution of the 5th schedule, which restrict land transfers, and if we try to analyze the basic features of the 5th schedule in a very succinct manner, we see that it restricts land transfer, it modify applicability of the laws to tribal areas, and it also try to see a tribal advisory council to have the role of the tribal community and their cultural uniqueness are to be protected. Thus, in this context, we see that what has been a special power and a special rights which has been conferred under Indian Constitution vis-a-vis if we see at the India's forest biodiversity and the tribal presence, then we see that there has been a 40% of development have taken place and they have displaced the tribal people. Therefore, the Forest Right Act is trying to resolve the historical discrimination by restoring access to land, right to resources and right to livelihood, and thus we see that what this law is going to do is in consonance with ILO Convention 107 and 169, and as well as it is in consonance with the Universal Declaration of Human Rights 1948 and International Covenant on Civil and Political Rights 1966, as well as Convention on Biological Diversity, which talks about equitable benefit sharing and sustainable use, and adopts a community oriented IPR system, intellectual property rights system, which is juxtaposed to the TRIPS model of the law, which tries to see the intellectual property right from the perspective of the corporate and it is trade related aspect, whereas the Convention on Biological Diversity is a community oriented intellectual property and their traditional right and which has been historically in existence are to be realized. Under this context, we see the committee report, and we have already discussed about the B.D. Sharma committee report's finding and national forest policy is concerned, and we here see that how the Banwasi Seva Ashram case has also recognized, Supreme Court has recognized need to balance the conservation with the tribal community near Banaras, and near Banaras that some factory was going to be created in the hinterland of the tribal community near Chunar, and Mirzapur district of the Uttar Pradesh, it joining Banaras and Chunar, and in this case that tribal community who have contested the very location of the industry, the Supreme Court have tried to remark and observe that their right should be recognized, and they directed displacement of the tribal community before eviction from the hinterland and the forest. T.N. Godavaran cases in the series of the cases is something a very salutary development, which have taken a very comprehensive view and a holistic view of the forest governance. Vis-a-vis, it also triggered some legal reform and the policy reform, and by way of reform, it emphasized on the role of tribal right and joint forest management with a very harmonious construction of the development and as well as the forest conservation. And thus we see that overall trend which emerges from these cases is to rehabilitation, resettlement, recognition of right, and the communitarian involvement in developmental project, as well as to see that how the forests are to be protected and conserved by their historical wisdom and traditional wisdom. So, taken as a whole, the 6th chapter and 14th section, which defines individual right, community forest resource, habitat rights, and try to see restored tenure and tenancy right and security, and strengthening the conservation ethics of the forest dwelling community and other traditional forest dweller and community forest resources and the forest land and bona fide livelihood needs. We see that the entire question of the habitat and the critical habitat has also been conferred some power to the forest dwelling community by identifying by the expert consultation and giving some right which can be modified after the strict procedure and consent. In this respect, we see that the law relating to Forest Right Act have been very progressive in giving effect to bamboo, cane, honey, wax, herbs, roots, tendu, leaves, meaning thereby conferring the minor forest produce right is something very important in the context, and it also states the duties regarding that the corporations and the forest department should not act as a corporation and shun away with the tendency of the monopolization and exempt the minor forest produce from the transit restrictions. Villages like forest villages, revenue villages, old habitation, unsurveyed settlement, traditional tribal rights have also been allowed to come within the purview of the rights of the traditional community. Then we see that the nature and the gamut of the community right and customary right which we have noticed under this law, that how this law is going to act their rights are going to be acted upon in matters of national park and sanctuary, because that is one of the most controversial area, and in this case the Forest Right Act have recognized even in the protected area in matters of their coexistence, if it is impossible or scientific evidence suggests supports their removal, then only they are to be sanitized and they are to be evicted. Otherwise, they are to be retained in the even national park and the sanctuary. And in case that such an unpleasant decision of eviction is being taken place, then it should be backed up by rehabilitation package and rehabilitation and resettlement. And section 3 subclause 2 try to see a minor changes in conferring the rights on the forest dwelling community, and that minor changes of 1 hectare of land may be converted for their own survival, livelihood in matters of right to education, right to health, and some social security schemes of Anganwadi. There it is left on the Gram Sabha to chalk out a plan and to see such diversion and eviction can be tolerated to certain extent. In this case, on this count, we see the Supreme Court decision in Nyamgiri case where the forest right cannot be bypassed for mining or any kind of a development. Thus, we see that it recognizes even in the national park sanctuaries and even in the developmental project, they are to be given some kind of a representation and it cannot be bypassed, more so for some electricity, drinking water pipeline, community needs and school and hospital. some minor conversion of the forest land can also be tolerated. Thus, we see that there is a large list of the duties of the forest right holder in matters of protection of wildlife, forest biodiversity, water resources, and ecologically sensitive area to maintain cultural and natural heritage and follow strictly the rules laid down by the Gram Sabha in matters of conservation of the forest and the wildlife. Thus, we see that the Forest Right Act and community-led conversion, they are going to be custodian and not encroacher. That kind of a fundamental shift has been brought by this law, and now it's very pleasant to see that their community rights are being strengthened in conservation ethics by promoting sustainable use. And we see, on the other hand, the other law which is of far-reaching significance is the Panchayat Extension to Scheduled Areas Act 1996, known as PESA, which applies to tribal areas, also empowers Gram Sabha for minor forest produce as a matter of ownership. It also grants land use approval. It also talks about the conservation and dispute resolution, and by way of extension to scheduled areas, here it means the Panchayat extension to scheduled areas, then it tries to strengthen all these rights into the very governance ethos of the local self-government by strengthening the Panchayat Extension to Scheduled Areas Act of 1990. We also see that how the Forest Conservation Act 1980 took away the rights of the state government to convert forest land for non-forest purposes are being partly answered by the Panchayat Extension to Scheduled Areas Act of 1996, and how the Supreme Court in 1996, having enlarged the definition of the forest cover or the forest produce, have conferred a variety of the right to the forest dwelling community, which is necessarily be involved in conservation and preservation of the forest, including the wildlife. Thus, we see that what has been laid down in the 5th schedule to the Constitution, and as a natural sequel to it, that the Panchayat Extension to Scheduled Areas Act 1986 in the right earnest develops some participatory democracy, and it confers some very fundamental right in the political, that is social, economic, cultural and political life of the scheduled tribes and Adivasis in this country, and for the management of natural resources. So, this point also go hand in hand in relation to the salient features of the Panchayati Raj, which tries to see the role of Gram Sabha in a larger scale and larger magnitude to develop in the light of the customary law, social and religious practices and traditional management practices of the community resources. And this law is a great armory in the hands of the forest conserver and forest planner, forest administrator and forest legislator, and whosoever is planning in regard to the forest. Then we see that the independent India's forest policy and laws from the colonial York have decent perceptible changes, and those perceptible changes happens to be something very remarkable and revolutionary changes which are being brought by the Forest Rights Act of 2000 and as well as Panchayat Extension to Scheduled Areas Act 1996 to confirm the basic constitutional conscience and ethos which is underpinned in the fifth schedule, and the special power which is conferred to the administration of the scheduled tribe areas. And we see the forest conservation and protection in a larger framework of people and communitarian perspective, and here these two laws thus clubbed together concludes our discussion on India's forest policy and law, and try to see that how it is going to be a transformative changes which for the first time uphold the constitutional justice and human right by giving a sustainable support to community-led forest governance, and that is said to be a remarkable social justice and balancing the livelihood and ecology requirement by the fold of Forest Rights Act 2000 and the Panchayat extension to scheduled areas of 1996. With this, the discussion or our discussion from forest policy and laws in colonial India, independent India, and, and the contemporary India concludes, and I thank and I wish you a happy learning.